Hello all and welcome to Trinity Chambers Junior Litigators Toolkit. The format of the talk today is that there will be four about 15-minute talks followed by some questions. Thank you very much to those of you who have sent in questions in advance. I'll be putting those questions to our speakers later on. For those of you who have questions while the talk's ongoing, there won't be time at the end, unfortunately, to deal with those questions, but if you'd like to send them to events@trinitychambers.co.uk, we'll respond to any queries that you may have. Without any further ado, I'll hand over to the speakers.
Good afternoon, I'm Chris Hegarty. I'm talking a bit about common problems with applications and bundles. Now, applications, as we're all aware, most of them are relatively straightforward, but three problems do seem to arise that are worth discussing. Firstly, the time frame for service and response to applications. Obviously, where there is a court order in place or directions have been given, then that needs to be complied with first and foremost. And certain applications, particularly those in Part 24 for summary judgment, Part 25 for interim remedies, have their own rules. More generally, however, Part 23 applications don't have any more specific rules. The only one of relevance to the applicant is 23.7, that is, the application and evidence must be served as soon as possible and at least 3 clear days before the hearing. That's important because the evidence in response, unless direction has been given of course, is only referred to in Practice Section 23 at paragraph 9.4, that is, as soon as possible. Obviously if there are directions, they must be made instead. But in cases where you have a telephone hearing, as is more common these days, paragraph 6.11 through 6.13 require documents, whether from the applicant or the respondent, to be filed and served by 4 p.m. 2 days before the hearing. This is a very narrow window and one that can catch people out. So after timeframes, the other question is what goes where when making your application? We're all familiar with the N244. The front page of it requires you to specify what you're asking the court for and why. The reverse of it includes space for evidence, very often replaced by a full witness statement. Distinguishing between those two is what's important. What you're asking for and why is a short statement of what power you're asking the court to exercise and why it ought to exercise it. The evidence in support is what follows it. Notably, neither of these are your argument. That comes later at the hearing or in the form of a skeleton argument. When it comes to your evidence, most applications have a fairly well-known test, and judges up and down the country are very familiar with the rules they have to apply and the process they've got to go through to determine whether or not they ought to grant an application or exercise their discretion as you wish them to do so. So quoting that doesn't earn points, nor does extensive quotation of case law. The judge will have their white book to hand and will know what they're going to be doing with your application. However, what is useful is headlining, headings, and taking the judge through your evidence in a way that allows them to apply the test quickly, mentally. Headings allow you to guide the judge through what they should do and in a simple, easy and clear fashion. They also demonstrate to the judge that you know what test they're going to apply and why they ought to rule in your favour. This also helps build credibility by showing the judge that you have thought about the application and understand what it is you're asking for and why they ought to grant it. Sticking to the facts within that also keeps your statement, your evidence, short. The shorter it is, the swifter the judge is able to read through it, understand it and follow what you're after. Finally, you end up showing the judge that you are not just paying lip service to the overriding objective, you are treating the court's time with the respect it deserves and enabling the judge to get through your evidence much more swiftly. There is always a temptation to include argument. Your witness statement isn't the place for it. A skeleton argument will, in a bundle, end up in front of your witness evidence and will take a judge through that evidence. So you don't need to put all your argument in a witness statement. The third problem that has cropped up are applications without a hearing under CPR 23.8. Some rules make provision that the application ought to be done on the papers for example, in relation to permission to appeal, and those do not necessarily fall within the general rules in Part 23. 23.8 envisages three situations in which an application can be made without a hearing. Firstly, the simple one, a consent order. If both parties agree what they want the court to do, then a consent order can be filed, provided that it is something that you can consent to. Certain dates, particularly trial dates, can't be moved, and it's unwise to ask a court to do so by consent. The two rarer varieties are 23.8b, where the parties agree the court should dispose of the application without a hearing. One simple example is dealing with choosing experts from a list when the parties just hit the point they can't decide between them, but they have a list. The rules require that the parties both give clear consent to disposal without a hearing, and pragmatically, you need to ensure that everything the court will want to consider is placed before the court. Now, where the court does decide to proceed without a hearing, process set out in paragraphs 2.3 through 2.6 of Practice Action to Part 23 is followed. So a judge will consider whether or not the application is suitable to be determined on the papers. If so, it will give directions. If not, it will give directions, but to list a hearing. So even if an application is made under Part 23.8b, it may end up at a hearing if the judge doesn't consider it suitable. Finally, 23.8c deals with those where the court does not consider a hearing would be appropriate. This results in orders which a party can apply to have stayed, varied or set aside pursuant to CPR 3.35 as if these were orders of the court's own motion. Therefore, if such an order is sought and made, the respondent can always apply to have it set aside or varied and essentially reheard. Now, bundles. Bundles are needed more than ever at the moment, particularly when dealing with smaller applications where very often a judge would have before him an application bundle, respondent's evidence and potentially the court file in front of him. These days, a lot of judges are sitting remotely, do not have access to the court file, and a hearing bundle is absolutely vital for the hearing to be effective. You'll have seen the directions regularly over the last year or so. Secondly, these comments do apply to trial bundles. They are somewhat heavier, but the same rules apply across all sorts of hearing bundles. The first guidance on bundling can be found at Practice Section 32, paragraphs 27.1, and these set out a list of items to include, particularly a case summary, chronology, followed by your statements of case, your orders, any other applications, directions questionnaires, budgets, disclosure lists, expert reports, witness statements, and other documentary evidence. Other documentary evidence is an important one to watch out for, and it's worth looking at paragraph 23.39 of the Chancery Guide, because very often a lot of the documents that have been exhibited to witness statements will in fact fall within other parts of a bundle, and it's appropriate to mark up witness statements to direct the reader to where that document has ended up in the bundle, and or to include placeholder pages to redirect the reader from the exhibit to the proper place for the document. This avoids a significant amount of duplication, which is easy to build up, particularly in cases where we have case management conferences and multiple applications. We don't want multiple copies of all the court documents. Finally, don't forget to include things like your draft order, your placeholders for your cost schedules, and your skeleton arguments, particularly if the bundle is going to be filed on paper, as is still required for trial bundles. Now, having looked at Practice Section 32, paragraph 27 onwards, the first and most important of those is paragraph 27.1. This puts a duty on the parties to use their best endeavours to agree the contents of a bundle. It's not somewhere for satellite litigation. You'll also find guidance in the Chancery Guide at 15.34 onwards and 21.34 onwards, and in case in the Queen's Bench Division, Practice Section 51.0, paragraphs 10 and 13, regarding the electronic working pilot, particularly the need to file paper copies of bundles in some circumstances. On to e-bundling, the key guidance is that from Lady Justice Thirlwell, President McFarlane and Mr Justice Mann from May 2020. This does change some of the rules and is referred to in the latest versions of both the Queen's Bench and Chancery Guides. The major update is to how numbering is to be organised. Page numbering is no longer continuous from the beginning throughout. It should take the form tab letter followed by page number within that tab, and if additional pages are required, a full stop and then numbering within that additional part of the tab. It also requires you to make sure that your PDF bundles are A4, they're OCR'd and they're rotated so that the reader can view landscape pages with a single rotation clockwise. It also provides us handy guidance that each email addresses can take bundles up to 150 megabytes, but watch out for Practice Direction 51.0, which sets other rules regarding filing of documents in certain cases. And however, justice.gov.uk email addresses can only take 36 megabytes. Watch out for your file sizes because a 36 megabyte bundle will not arrive and may fail silently. The worst thing to happen is for you to not know that your bundle hasn't gotten there. For larger bundles, look at using a file sharing platform and make sure they're GDPR compliant. Your firm's IT department has probably made a decision as to what is being used. Finally, watch out for no bundle, no hearing rules. The Insolvency and Companies Court is very strict about this per Chancery Guide, paragraph 25.41. If you turn up to a hearing and there hasn't been a bundle properly filed, you will not have a hearing, you will be adjourned off. This can lead to very unhappy clients. Queen's Bench Division is a bit more generous, as is the Chancery Guide generally, paragraphs 3.31 and 15.34 respectively, where if the hearing can't reasonably proceed without a bundle, it will be adjourned, but otherwise you may manage to proceed. However, particularly at present, it's not worth not having a proper hearing bundle that will be effective. Thank you very much.
Good afternoon, everyone. I'm very happy to be here talking to you today, although I appear to have drawn the short straw a little bit in terms of topic, as I have the pleasure of talking to you all about disclosure. And specifically, I'm going to be looking at the disclosure pilot scheme, which applies to cases in the business and property courts. I imagine most of those listening will be familiar with the disclosure pilot scheme, but for the benefit of those who aren't, I'm just going to briefly summarise the background to the pilot. I'm then going to move on to talk about and focus on some of the recent amendments to it, which have come into place in April of this year. And finally, I'll end by just giving a couple of pointers as to how to approach cases where the disclosure pilot applies. The disclosure pilot scheme is contained in Practice Direction 51U of the Civil Procedure Rules, and it came into force on the 1st of January 2019. It was originally intended to run for 2 years, but it's now been extended for an additional year, and so is due to end on the 31st of December of 2021. Looking beyond that, though, I think the smart money is probably on the scheme continuing in some shape or form in the future, and therefore it's good to be able to get to grips with it now, whilst everybody else is in the same boat. The disclosure pilot scheme was designed to address some of the issues which lawyers had historically encountered with the standard disclosure regime, namely that it was becoming increasingly inefficient, that it was not cost effective, and that it was struggling to deal with the large volume of e-disclosure which is now commonly involved in business and property cases. In addressing those issues, the disclosure pilot has also set out to usher in a complete culture change in how lawyers approach the disclosure exercise, one based on the principles of reasonableness, of proportionality, and importantly, and perhaps most ambitiously, cooperation between the parties. Just to briefly then run through the key features of the pilot, first of all, it establishes several new definitions, including an expansive definition of document, which now specifically includes reference to electronic information held on computers, USBs, mobile phones, remote backup systems, and also audio and visual material, and also metadata. In addition, the pilot codifies a wide range of duties which apply to both parties and to their legal representatives relating to the disclosure, retention, and preservation of documents. In terms of the process of disclosure, the pilot starts with an initial disclosure stage where parties disclose, along with their statement of case, any key documents which they've relied upon in preparing that statement of case, or documents that are necessary to help the other party to understand the claim, unless this is going to exceed either 1,000 pages or 200 documents. Within 28 days of the service of the final statement of case, the parties must then state whether they require what's called extended disclosure, which is based upon 5 different models. First of all, you have Model A disclosure, which is disclosure limited to known adverse documents. So these are documents which a party is aware of and which contain information that contradicts or materially damages the disclosing party's contention or version of events in regards to a particular issue in dispute. There's then Model B disclosure, which again is disclosure limited to key documents, and effectively that's based on the same test as for initial disclosure, but doesn't have the same page limit or document limit attached to it. There's then Models C, D and E, which are all different forms of what's called search-based extended disclosure, ranging from very narrow searches for particular documents or narrow classes of documents to broader searches and also to train of inquiry disclosure. Where extended disclosure is envisaged, the claimant should prepare a list of issues of disclosure, and then both parties should seek to agree what's called the disclosure review document. And that's one of the key features of the disclosure pilot. And essentially it's a document setting out all of the lists of issues for disclosure and how each party proposes that these should be dealt with and which model they propose should be used. It should be stressed that there's no entitlement to any of these forms of extended disclosure, and in all cases the court must be satisfied that an order for extended disclosure is reasonable and proportionate, having regard to the overriding objective and the factors that are set out at paragraph 6.4 of the practice direction. There are many other features to the scheme as well, as we'll come to talk about, but in a nutshell I think that very much sets out the broad scheme of the disclosure pilot. And this was intended to be a living pilot, and as it's progressed, research has been carried out by Professor Mulheron of Queen Mary University of London to see just how well the scheme has been working in practice. And if you're ever having any days where you're tearing your hair out or having sleepless nights trying to implement the pilot, what her research shows is that you're not alone. And she's received a number of responses from very senior practitioners suggesting that the disclosure pilot has been less accurate than standard disclosure, has been increasing the regulatory burden on both parties and lawyers, has actually ended up increasing the costs for disclosure, and has so far failed to bring about any meaningful change in terms of culture. Naturally, there are always going to be some teething problems, and in light of Professor Mulheron's reports, there have been a number of amendments made to the disclosure pilot, which came into force on the 6th of April 2021 as part of the 127th Practice Direction update. And I'm now just going to go through and summarise a few of those key changes. First of all, there's been a change to the scope of the duty on parties and lawyers to take reasonable steps to preserve documents. It used to be the case under paragraph 4.22 that a party's duty to preserve documents required them to notify all relevant employees and former employees, essentially to ask them to preserve any documents which may be relevant to the case and may require disclosure in future. Practically speaking, this was causing a number of difficulties, not least of all the fact that it could often be a time-consuming and laborious process to track down any number of former employees, particularly in cases that might span several years or even decades, and that this was leading to a considerable amount of work, increased cost, and ultimately the documents that were being returned were simply duplicates of documents parties already had. Now, in light of these issues, and the obligation at paragraph 4.22 has now been qualified so that relevant employees and former employees need only be notified where there are reasonable grounds for believing that they may be in possession of disclosable documents which are not also in the party's possession. So clearly this is a much narrower focus than before and hopefully should reduce the time involved in carrying out this duty and also therefore decrease costs. The drafting now also clarifies that lawyers don't have to write to their own employees or former employees of their law firm. It's the party's employees who are important, and whilst that may seem obvious, it wasn't clear on the previous form of drafting. The second point to be aware of is that there has been clarification of when adverse documents need to be disclosed in proceedings. This was another bugbear raised in Professor Mulheron's research, and the amendments now make clear at paragraph 5.44 that adverse documents do not need to be disclosed when giving initial disclosure. And this, of course, makes perfect sense because when you're first making your claim, you don't really want to be telling the other side exactly everything that's wrong with it. Paragraph 3.12 confirms now that the latest time for disclosing adverse documents is by the date ordered for extended disclosure. And if an adverse document should come to a party's attention after that date, then they simply must disclose it without delay. The third point to note is that there have been some changes to the disclosure review document itself. Now, I don't intend to go through all of those in detail because I think they're best seen on the red line version, which I've attached a link to in the handout. But in short, the document has been tweaked to try and make it more user-friendly, and there are now some additional guidance notes in terms of completing it, which in effect give the parties more discretion to tailor the document to a particular case, and also make clear that only relevant sections should be filled in. The most welcome change, though, is that the disclosure review document needs only to be completed where search-based extended disclosure is sought. So that's where you're looking at disclosure along the lines of models C, D, and E. If the parties agree that only models A or B will be used, then there's no need to complete the disclosure review document anymore, and likewise you won't have to complete a list of issues of disclosure. The fourth area where there have been changes concerns disclosure guidance hearings. Now, these are essentially short telephone appointments where parties could get a steer from the judge on any disclosure issues without any cost risk attached. Now, I don't know if anyone actually has any experience of using or applying for any of these hearings, but in practice it seems like they simply weren't being used very much. And as such, there have been some amendments to paragraph 11 of the practice direction in the hopes of making them more accessible and more user-friendly. Guidance is now available on any point concerning the operation of the pilot, whereas previously it had been limited to the scope and implementation of extended disclosure. What's also been removed is that the requirement that the absence of guidance from the court is likely to have a material effect on the court's ability to carry out an effective CMC or the party's ability to carry out case management directions effectively. On paper, that sounded like a fairly high threshold to pass simply to have a guidance hearing. And now all that's required is that the parties have made real efforts to address the point between themselves, that the point requires guidance rather than a ruling, and that it is suitable for a hearing with only 30 minutes reading time and 30 minutes hearing time. Although there is now a slight caveat that the court can agree to extend that hearing time if required. Interestingly, there's also now an option for the judge to deal with a disclosure guidance hearing on the papers, which may be an interesting option for clients and provide more accessibility to guidance hearings and reduce the cost of attendance. On a related note, I should also add that parties can now also apply to court for an order giving directions about any aspect of search-based extended disclosure. So effectively, if there is a disagreement down the line as to how extended disclosure should take place and the scope of that disclosure or any use of technology, then the matter can be brought back to court quickly. So those, as I see it, are the main changes that have been brought in as a result of the practice direction update. But I'd urge everyone to have a look through the red line, which I provided a link to on the handout, which should show all of the various typographical tweaks and other changes that have been made. And that leads me lastly on to my tips as to how to approach cases where the disclosure pilot applies. And I think first of all what I'd say is that it's important to familiarise yourself not just with the duties that apply to clients and to lawyers in regards to disclosure, but in particular the different models of disclosure that have been introduced, how they work and where they're best used. The pilot is designed to be deliberately flexible, and it gives the court a really broad range of powers at paragraphs 9.6 and 9.7 to limit the scope of disclosure and indeed to specify certain date ranges, certain file types, geographic locations, computer systems, and even specific keyword searches. So you really have the tools here to tightly control disclosure and to be very specific about what it is you're looking for, and as a result to reduce time and costs. And it's really important to be familiar with all of these powers and all of these options, as if you aren't proactive in asking for them, then the likelihood is that the court will simply look to the path of least resistance, which is making a disclosure order in very general terms. It's also really important to establish at an early stage whether the disclosure pilot is going to apply to your case, because the duties for disclosure, and in particular the retention and preservation of documents, start to bite very quickly, and indeed effectively at the contemplation stage of proceedings. So at a pre-action stage, you should really be asking, is this a case that's likely to be issued in the business and property courts? And if so, if you're the claimant, in the spirit of cooperation, you should probably make your opponent aware of that. And if you're a defendant and you suspect that a case is going to be issued as a business and property case, it's important that you start complying with the duties under the disclosure pilot without delay. It's also perhaps an obvious point, but it's important to try and cooperate as much as possible with the other side, not only to avoid any adverse cost consequences which may apply down the line, but in helping resolve any teething problems that might still be there with the pilot, and just to clarify how each issue should be resolved. And I think when you're doing that, sometimes there's a tendency to get bogged down in correspondence, and I think I'd recommend, first of all, just picking up the phone to your opponent and seeing whether you can chat through the issues and resolve matters that way. And lastly, and just building off Chris's talk and the points on e-bundling, I think it's also important to keep an eye on legal tech and what tools are available to help with e-disclosure. Now, some firms are much better than others with this, but legal tech is something where younger practitioners maybe find it easier to take a leading role. And I think in the long term, it's an area which is constantly developing and is somewhere where you can really add value for clients and help simplify the disclosure process. Thank you very much for listening today. I hope that's been a helpful talk, and any questions, please do feel free to get in touch.
Good afternoon, everybody. Thank you very much for tuning in. Jack told you earlier that he'd drawn the short straw on topics, but I have the honour of addressing you on the most interesting topic of all, which is cost budgeting. I'll be looking at some of the more riveting recent developments in the guideline hourly rates, the very exciting difference between incurred and estimated costs, and the frankly thrilling new procedure on revising your cost budget. Now, one of the first things that parties will look to do when questioning someone's cost budget is looking at the rate that is being claimed by the fee earner. And very often this is done by comparing the guideline hourly rates with the rates that are claimed. The issue with this is that the guidelines that are applicable have been applicable since 2010 and haven't been addressed or updated to reflect inflation or changing market rates. And whilst judges do have a discretion to depart from the guidelines, such discretion is applied reasonably inconsistently. And very recently a case called PLK and others was addressing this very topic, and the High Court were assessing quarter protection costs, and they noted that the guideline rates really needed an uplift to reflect inflation and commercial pressures, and that whilst the court themselves didn't have a power to amend those guidelines, they could at least give some guidance on how to apply them, and to apply them with broad, pragmatic flexibility. And if the hourly rates claimed fall within approximately 120% of the guideline hourly rates, the High Court felt that that should be prima facie reasonable, and that above that percentage would be correspondingly unreasonable. And that applied both a similar approach applied in the Business and Property Court in Cohen and Fine. And that was where His Honour Judge Hodge QC allowed a 35% increase on the 2010 guideline hourly rates, again adjusting for inflation using the Bank of England calculator, and he based that on his experience sitting as a Business and Property Court judge in London and the North West. In 2021, in January this year, the Civil Justice Council published a working group report addressing this very issue. It's a 100-page report. You should add it to your bedtime reading list, but for those who have got more interesting things to do, I'll deal with some of the recommendations and conclusions in summary. So, the Civil Justice Council reiterated that the guideline rates are just that, they're guidelines. They can be departed from, discretion can be used. But it nonetheless recommended an increase to those rates of between 7% and 35%, depending on your grade and location. There was some redefining of what constituted bands 1 and 2 in London. There was a merger of national bands 2 and 3, and whilst national bands 1 and 2 were kept separate, the Civil Justice Council didn't rule out future review and merging them into a single national practice, one which may well follow following revised working practices as a result of the pandemic. And it was also recommended that guideline rates should be updated annually in accordance with an appropriate SPPI index to account, no doubt, for inflation. There was a consultation arranged that ended at the end of March 2021. We're currently awaiting the outcome of that consultation to see if it had any impact on those recommendations. But going forward, I think it's important that practitioners should be ready for this change, but remembering that the assessment is still the same. The method is not changing, just the guidelines. So practitioners should bear the indemnity principle in mind, but be happy, no doubt, that the long overdue update to the guideline rates is on its way. Another thing that's important in cost budgeting is the difference between incurred costs and estimated costs. Because when it comes to cost budgeting, the court will only deal with estimated costs when it conducts its budgeting exercise. And under CPR 3.15, all costs up to and including the CCMC are classed as incurred. So at the CCMC itself, what usually happens is that whilst the CCMC, when the budget was sent in, was estimated, the CCMC will be moved over to incurred and the court won't interfere with those costs. Inevitably, that leads to some difficulties for practitioners who are estimating the costs of preparing for and attending the CCMC when they first file their budget. What the guidance is on that is that in higher value cases where cost budgets don't need to be filed until 21 days before the hearing, practitioners should essentially wait until almost the last minute to ensure that they are as accurate as possible. But in lower value cases, it's maybe better to update the budget closer to the time, closer to the hearing, so that again, those costs are as accurate as possible. And whilst the court can make comment on the incurred costs, they can't interfere with those. That's for detailed assessment. But no doubt the comments made at the CCMC stage will influence the judge dealing with the detailed assessment proceedings. So don't think that that one can get away with overinflating their costs at the incurred stage, because it may well come back to bite you. And similarly, if at the budgeting stage you have rather high incurred costs, the court can take those into account when budgeting the estimated costs. It may see overlap between the incurred costs and work already done and reduce the estimated costs accordingly. So again, be careful with your incurred costs. The final part of the recent update that I want to deal with is the Precedent T procedure, which is a new procedure introduced by the 122nd Practice Direction Update, and this introduces a long overdue process for revising a cost budget. So you have to complete a document called a Precedent T, and CPR 3.15a deals with the procedure. It applies where there are significant developments in the litigation which warrant such revisions, and you must submit those revised budgets promptly. So the question then is, firstly, what are significant developments in litigation? Well, in Seekings and Moores in 2019, the High Court said that it was something that was not or could not have been reasonably anticipated at the time you were agreeing or approving your first budget. And that's clearly a fact-sensitive test, but some examples of significant developments are the grant of a permission to call additional expert witnesses, the adjournment of a trial, the increase in the number of days needed for the trial, and the receipt of far more disclosure than could have reasonably been foreseen at first. It's also important that the precedent is submitted to your opponent for agreement before it's filed at court, and when you do file it at court, you have to submit it with your last approved budget so that you can show what changes have been made, and with an explanation as to any disagreements between yourself and your opponent. The court then has a complete discretion. It may decide the issues on paper, or it may schedule a hearing. And the costs of actually applying for that revision and going through that process will fall under the 2% cap for all other recoverable costs in association with your budgeting exercise. Equally, though, the court may disapply that cap if it feels that the exercise that you've undertaken is particularly intensive as a result of those significant developments. So that is the whistle-stop tour of costs. I hope you've enjoyed. Thank you very much for listening.
I'll be setting out the new rules on trial witness statements within the business and property courts, introduced by Practice Direction 57AC. I'll firstly set out the kinds of witness statements and proceedings which are affected by the new practice direction, and equally the proceedings which are not affected by it. The purpose of the new rules provided in Practice Direction 57AC, and finally the drafting of and the content of the witness statements. On 1st February 2020, the 127th update Practice Direction Amendments was published. It includes the new practice direction on trial witness statements in the business and property courts, which came into effect on 6th April 2021. The new practice direction applies to trial witness statements signed on or after 6th April 2021 in both new and existing proceedings in the business and property courts. The practice direction specifies that trial means a final trial hearing, whether of all issues or of only one or some particular issues in proceedings, under CPR Part 7 or Part 8. Given the definition of trial, it seems clear that Practice Direction 57AC applies to witness statements for use in preliminary issue trials, as well as in other types of final trial hearings. However, it does not apply to witness statements for use in interim applications. That said, it is possible that the new rules will encourage greater scrutiny of witness statements generally and lead to the pre-existing requirements for all witness statements being applied more stringently. There are also, however, specific proceedings in which Practice Direction 57AC does not apply. Paragraph 1.3 within the Practice Direction lists several types of proceedings to which the Practice Direction does not apply unless the court directs otherwise. These include certain applications under the Financial Services and Markets Act 2000, certain intellectual property enterprise court proceedings, proceedings falling within CPR Part 57, and proceedings under CPR Part 64. So a practical point, practitioners should check the list before preparing a trial witness statement in the business and property courts just to be sure that the type of proceedings with which they are involved in is not excluded from the requirements under Practice Direction 57AC. Paragraph 2 of the Practice Direction emphasises the purpose of a trial witness statement and sets out that it sets out in writing, the evidence in chief that a witness of fact would give if they were allowed to give oral evidence at trial without having provided a statement. It should inform the parties and the court of the evidence a party intends to rely on at trial, and it should thereby promote the overriding objective and help to put parties on an equal footing, saving time at trial because the court will be able to move straight into cross-examination, and promoting settlement before the trial, which in theory is nothing new, really. Paragraphs 3 to 4 of the Practice Direction gives directions as to the contents and other requirements for the statement. They provide that a trial statement must contain only evidence as to matters of fact of which the witness has personal knowledge that are relevant to the case and need to be proved at trial. It must list which documents, if any, the witness has referred to or been referred to for the purpose of providing the evidence in the statement. It must be prepared in accordance with the statement of best practice in relation to trial witness statements set out in the accompanying appendix entitled The Best Practice Statement and any relevant court guide. In the event of any inconsistency, the best practice statement will take precedence over the court guide. The statement must be verified by a statement of truth as required by CPR 22 and Practice Direction 32. It must include confirmation of compliance signed by the witness, and it must be endorsed with a certificate of compliance signed by the relevant legal representative. It's clear that one of the principal aims of the Practice Direction is to encourage careful thought about what factual evidence is required and how this is best provided. It also emphasises the need to differentiate between argument or submissions and evidence. Paragraph 3.3 helpfully clarifies, for the purposes of complying with the requirement in Practice Direction 32.18.1, that the witness statement be in the witness's own language. This also includes any language in which the witness is sufficiently fluent to give oral evidence and is not limited to a witness's first or native language. You might have guessed now that much of the new Practice Direction and its accompanying appendix recaps the purpose and requirements for witness statements already set out in CPR 32 and its accompanying Practice Direction and the relevant court guides. However, the three new requirements which should be taken note of are as follows, and I mentioned them earlier on. They are the requirement to list documents, confirmation of compliance, and the certificate of compliance. Firstly, the requirement to list documents under paragraph 3. Paragraph 3.2 provides that a trial statement must identify by list what documents, if any, the witness has referred to or been referred to for the purpose of providing the evidence set out in their trial witness statement. This means that to be able to comply with this obligation, a legal representative will need to know and keep a record of which documents were provided to a witness and when they were provided, and additionally, which documents the witness looked at of their own accord for the purpose of providing their evidence. Paragraph 3.2 expressly states that the requirement to list documents does not affect any privilege in any of those documents. In addition, the best practice statement in the appendix to the Practice Direction expressly confirms that it does not remove or limit any privilege that would otherwise attach to documents generated by or for the purpose of obtaining evidence for use in litigation. Information on how to identify documents in the document list, including privileged documents, can be found in the best practice statement in the appendix. There's currently no guidance on where the list of documents should appear in the witness statement. However, it is understood that it can either be incorporated into the body of the statement or be set out in an appendix to the witness statement. The Witness Evidence Working Group, which worked on the practice direction, have suggested that the requirement to list documents that the witness has referred to or been referred to tips the balance towards greater transparency and allows a witness to say that they could not remember the detail of a particular matter and that they refreshed their memory by looking at a particular document or documents. Secondly, the confirmation of compliance in paragraph 4. Unless the court orders otherwise, a trial witness statement must include the confirmation. The specific wording is provided at paragraph 4. The confirmation of compliance wording should be included in the witness statement itself, and it must be signed by the witness. Since this requirement is expressly in addition to the statement of truth required by Practice Direction 22, the confirmation will presumably have to be signed separately also. If a party wishes to depart from the requirement to include the confirmation of compliance statement or to vary the wording of the statement, they would have to apply to the court for permission. The application may and generally should be made without notice, and it will be determined on paper without a hearing. Thirdly, the certificate of compliance. Unless the relevant party is a litigant in person or the court orders otherwise, the trial witness statement must be endorsed with a certificate of compliance. Full wording is provided at paragraph 4. Trial witness statements covered by the practice direction should be prepared in accordance with the statement of best practice set out in the appendix to Practice Direction 57AC. The best practice statement starts by clarifying the court's approach to human memory when assessing witness evidence. In particular, the court recognises that human memory is a fluid and malleable state of perception and is vulnerable to being altered by a range of influences. The best practice statement then sets out the principles which should be followed, several of which reiterate some of the requirements under Practice Direction 57AC. This includes that the content should be limited to what would be the witness's evidence in chief if there was no statement. The best practice statement provides that statements should be as concise as possible without omitting anything of significance. They should not quote at length from any documents. They should not argue the case on any points. As noted earlier on, it's not an opportunity to make submissions. They should not take the court through the documents in the case or set out a narrative based on the documents. And they should not include commentary on other evidence in the case, which would amount to a matter of opinion or argument. Finally, the preparation of the statement should involve as few drafts as practicable. Paragraph 3.8 of the appendix to the new practice direction helpfully tells us that repeatedly honing a draft statement may corrupt rather than improve recollection. And in terms of the practical steps that practitioners can take to ensure compliance, firstly, you would need to determine whether the practice direction actually applies in your case. Is it a matter within the business and property courts? Is it a trial as defined? Consideration would need to be had as to whether the evidence is actually required. What are the issues of fact? Can the client's case be proven on the back of documentary evidence alone? If the witness statement is required before interview, explain to the witness the practice direction and accompanying statement of best practice, possibly in a standard explanatory note. Consider the interview questions. Avoid leading questions. In the interview itself, make a recording of the interview, maybe a digital recording, or take as detailed note as possible. And in terms of drafting the witness statement, it has to be drafted with close reference to the interview record. in the witness's own words, as few drafts as possible. And finally, it must include the certificate of truth and compliance. Thank you for listening, and if you do have any questions, please feel free to get in touch with me in Chambers.
Thanks again to those of you who've submitted questions. The first one that I've got is for Jack. Jack, are there any indications of what will happen once the disclosure pilot ends? Other than those which we probably can't talk about on a webinar, have any problems with the pilot scheme been acknowledged?
Starting with the first bit, I think that at the moment the indication is that any cases that had the disclosure pilot applying to them when the disclosure pilot ends on the 31st of December this year, the disclosure pilot will continue to apply to those cases. The bigger question is whether the pilot is actually going to end on the 31st of December or not, because at the moment the disclosure working group is suggesting that they're going to be bringing in further amendments in the autumn practice direction update. So one would have thought they'd want to have a bit longer after that to see how things actually pan out and whether those changes that they're going to bring in, whatever they may be, will actually have an impact or not. So I'd expect that actually the scheme's probably going to be extended. I'd have thought for at least another year to see what happens with that. And then after that point, the question is whether it's going to stay in place, and if so, in what form. And I think there's clearly a great deal of support for it from the higher judiciary, but not so much support at a local level. And in terms of the issues that have been raised, yes, I think they have acknowledged a lot of them. They've acknowledged that there's certainly been a lot of teething problems. The question is whether they're actually going to do very much about it. And the amendments I discussed in my talk before don't really go very far to addressing the fundamental problem of, does this actually reduce costs across the board? Is it only effective in large cases? Can it actually work where you're just dealing with maybe an owner business or with small businesses? And that's something they're really going to have to tackle. And I think going forward, that what they say they want is solutions, not problems. And certainly the reports from Professor Mulheron mostly just give all the problems that everyone has with the scheme and not really any solutions.
So Jack, on your reading in preparation for this talk, is there acknowledgement that actually, certainly in cases that I've done, it seems like the disclosure pilot has increased costs?
There is acknowledgement of that. The question is whether the powers that be see that as being a result of people not applying the pilot properly, or whether they see it as being actually a fundamental issue with the way in which it's designed. And to a degree, I think it's possibly too early to tell, and they've tried to steer people into a better understanding of how the different models of disclosure apply, and also I think to steer away a little bit from the search-based disclosure models, which obviously add to cost. But whether they really acknowledge the fact that this may not be suitable for your smaller run-of-the-mill cases, I'm not quite sure.
Patience, one for you on witness statements. What sanctions are there that can apply if the practice direction isn't properly followed or isn't followed at all?
So within the business and property courts, they do tend to have quite a wide discretion when it comes to sanctions, and particularly in respect of the new rules in regards to trial witness statements, the court can set aside a decision where a witness statement has not been drafted in compliance with the new rules. The court can make adverse cost directions in respect of that as well, and the court can also rule that a witness statement be dismissed and call the witness to give oral evidence instead of the witness statement filed.
Okay, thank you. Paul, over to you. How best would you say you prepare for a cost budgeting hearing?
Well, I guess from my perspective, obviously, I would like to know exactly how the cost budget has been prepared. Usually, cost budgets are prepared by cost draftsmen, and hopefully they can provide some kind of a crib sheet to me at the hearing to tell me exactly the basis on which they've prepared the budget. Equally, a conversation with my solicitors, if they've done it themselves, would be really helpful, just so that I know the assumptions on which they have made to put the number of hours in or the disbursements.
So what, fleshing out the assumptions that you get on the form itself, so that you've got that bit more detail to give the judge?
Exactly, because I've no doubt that a judge is going to be more persuaded to allow the budget that you've set out if you're able to give more precise detail to what those assumptions are. And one of the other things as well about preparing it is inevitably they're quite complex documents. They can occasionally be filed late, or parties will have to deal with what happens if my budget is late. The first thing really is don't panic. The White Book does actually provide for an explanation. You don't need to make a relief from sanction application. CPR 3.14 actually, it contains an express power where you can just effectively ask the court not to impose the sanction. It's unless the court orders otherwise. So you're not necessarily limited to applicable fees. Don't worry about the cost of a relief from sanction application. You might be able to argue it when you're there.
And I think certainly from my own practice, it's a classic example of where there can be opportunist attempts to make someone apply for relief from sanction when actually the cost budget coming in a day late or 2 days late has had no effect whatsoever on the litigation and no effect on the cost budgeting hearing. And I think that's starting to sound in adverse costs because of opportunistic points being taken when in fact it's probably something that should be dealt with by an agreed extension or a consent order.
Yeah.
Would you agree? Yeah, okay. Chris, one for you, an important one I think. For e-bundles, what would you say are the best ways to keep your judge happy, and perhaps ones that are surefire to make your judge unhappy?
Firstly, I'd make sure the bundle's OCR'd so it can be searched. Any bundle of any size needs to be searchable. It makes everyone's life much easier. Secondly, is getting your page numbering in alignment. Part of the PDF bundle guidance from the judiciary from May 2020 includes the new numbering standard, use of page labels in Adobe Acrobat. Yes, other software is available and has similar functionality, but by changing the page labels using prefixes, you can make sure the numbers in the bottom right corner line up with those that the software is using, so you can leap about your bundle much more efficiently.
And you've probably seen the danger where people manually paginate, scan it in, and potentially, because everyone paginates in the bottom right-hand corner, lots of people paginate in the bottom right-hand corner, the scanner misses out half those numbers halfway through the bundle, and so all of a sudden you're in that situation with the judge where you're telling them that it's at page 54 and they say, well, I don't know where that is.
Yes, exactly. When preparing an electronic bundle, most documents these days start out electronic, so going back to those electronic originals is usually better. The documents produce smaller, neater PDF bundles. You can stamp those numbers in the bottom right corner, so if a paper copy is required, Practice Direction 51.0 and the electronic working pilot requires it, you can make sure you've got identical PDF and paper bundles.
Patience, one thing which has been raised with me and is a question that we've had is that there are now at least 2 places within the White Book where there's guidance in the practice direction about what should and shouldn't be in witness statements. And they don't sing perfectly to one another. There's conflict there. Where you're preparing a witness statement for a business and property court case, what should you be doing if you've got 2 conflicting practice directions?
You're right, Richard, and it can be confusing. However, Practice Direction 57AC does say that where there is a conflict, then the new rules will prevail and take precedence.
Okay. That's a short and sweet answer. And a straightforward one, which is not always the case with additional practice directions. Paul, one for you. We've heard about the disclosure pilot. We know that it moves some aspects of disclosure around from what the traditional order of things would be. What's the effect that it has on cost budgeting?
Well, it's quite significant actually, because as Jack was pointing out, a lot of the disclosure takes place at the very start. So it's taking place on exchange of statements of case. You're doing the disclosure review document 28 days after that those are exchanged. So by the time you get to the CCMC, those are incurred costs, whereas normally you'd expect to see disclosure as estimated. And invariably you'll be dealing with requests for extended disclosure at the CCMC itself. So normally a judge would deal with that first, and then after deciding what extended disclosure is needed, it would be quite clear and obvious from the budget what is needed, how much money is going to be spent on searching for those specific documents that are left. So there should be a lot more precision in working out how much is going to be required for that disclosure, but it's probably worth budgeting on the basis that your opponent's requests for a disclosure are going to be granted, so that you know your starting points, then you can work down if the judge doesn't agree with all of those.
And I know you've talked about the way in which a judge can take into account what's on the incurred. Presumably you'd say that's disclosure is now somewhere where that's writ large. If you've incurred a vast amount on disclosure, you're not going to have a vast amount allowed at the other side of it as well.
Absolutely. So the estimated cost of disclosure should be significantly lower on the disclosure pilot than you would normally see, and you can take the judge to that, explain what you've already done. Again, that's where a crib sheet is really useful, so that you can explain with precision exactly what's being done.
And I suppose tying in with that, although I'm not sure it would be an answer that would allow you to explain your refusal, Jack, what steps should you give if the other party is refusing to provide initial disclosure?
It's one where the pilot isn't actually entirely clear as to what you should do, but it's something that may crop up, because certainly it's been raised in the criticisms of the pilot that some parties use the limit on initial disclosure of either 1,000 pages or 200 documents essentially as a way of hiding and getting out of providing initial disclosure, because obviously you can easily kind of inflate those totals. So there is an option under the pilot to apply to court for disclosure of documents which are necessary in understanding the case or in preparing your defence, which effectively mirrors the test for initial disclosure. But of course the court is going to apply that very, very narrowly to what that class of documents might be. But then the following paragraph, the court goes on to say that these sorts of issues will simply be dealt with at the CMC. So the question is, when would you actually be using that power to apply to court for a determination on initial disclosure? So it's probably only be in exceptional cases that you'd actually apply prior to the CMC.
So if, for example, you had a case which involved misappropriation of funds but also included some alleged contracts down the line, and for the initial disclosure you've got 200 pages of bank statements, none of the contracts, none of the potential deeds or whatever, that's presumably the kind of territory where
you'd want to apply sooner. I think so, but then you always obviously have the option of applying for adverse cost consequences if at the CMC the judge determines that initial disclosure should have been granted, because clearly the ethos of the pilot is cooperation. You shouldn't be trying to conceal or hide documents at any stage.
Okay, thank you. Chris, and obviously you've covered with notice applications in some depth, what's the correct approach, both in person and virtually, where you've got ex parte without notice applications, in terms of bundles and the kind of documents you should be looking to put in front of your judge?
It's a vital point, because one of the overriding issues with without notice applications is the duty of candor. Firstly, we can only get without notice applications where you're allowed to by rule, practice, direction or order. And there's limited scope for you to apply without the other side knowing what's going on, which is why the duty of candour is so important. You have to include everything adverse that a judge may wish to see. There's been recent fairly strenuous criticism of parties applying with less than utmost candour, and it's important to get those in the bundle, and practically to organise things for ease of service, because the first step when you get your order, if you get your order, is going to be service of the application, the evidence in support and the order itself, whatever the form of without notice application.
So if you've got an e-bundle that you're putting together and you've got some documents that you know that realistically a defendant or respondent to the application would be relying on, they should be in the back of that bundle, possibly with a tab to make it easy to find them for the judge.
Yeah, absolutely. You need to apply that duty of candour very carefully. A judge will not be happy if things crop up in a defendant's or respondent's response that you had access to that come up later. And it also makes it easier for the respondent to understand if they have a challenge on that basis on a later return date, if you've been less than candid.
Paul, one for you. What is most likely to be criticised about a cost budget, which is likely to lead to reductions in the amount that's been budgeted?
Well, I think, again, I'll go back to what I've said earlier. Ultimately, if there's something on there that you can't explain or doesn't appear to be obvious on the face of the bundle, on the face of the budget, and if you can't explain it, I don't think a judge is going to be very much persuaded to allow that. I think often I've seen overlap between counsel and solicitor fee earners, where I've seen either an over-reliance on counsel, involvement in stages which don't necessarily need, he or she doesn't need to be involved in, witness statements, disclosure. Unless it's a particularly complex case, it's probably not needed. So again, there'll probably be a reduction to reflect that. But if there are times when counsel are needed, often a judge will say, well, there's no need for the solicitor to be involved as much. So again, there'll be probably a reduction for the involvement of a solicitor in that stage.
And so going back, I suppose, to what you were saying earlier, if you know that there's that risk of it being perceived as overlap, that's a good place in which you might get a crib sheet from either the cost draftsman or the solicitor explaining what's envisaged, where there is that, on the face of it,
exactly,
close working at least and possibly overlap.
And it's important, not only are you able to explain it to the judge, but no doubt when you're instructing a cost draftsman, you need to be able to explain the particular complexities of your case to the cost draftsman so that they know that, okay, I need to add a certain amount to a certain section because I know that it's likely to come up because of this particular feature of this case. And then as long as you can feed that back in the hearing, hopefully that's going to protect you from that being reduced.
And the last question that I've got that's come in is for all of you really, and that's whether there are any trends or tips from recent times that you're able to give in relation to relief from sanction applications.
I mean, the first thing that I always deal with is last-minute oral applications, which often arise just because of maybe poor preparation by the other side. And the first thing I will be saying is, well, the application can be made orally, but where is your evidence? It needs to be supported by evidence. And if they can't give reasons as to why the sanction is, well, why they need that relief, that's the first point I'll be asking the court to note, that unless there are these reasons supplied in written evidence, the court are going to struggle to grant relief.
So regardless of how close you are to the substantive case management hearing or substantive hearing, get in an application if you can with witness evidence.
Just get witness evidence. Get a statement in as soon as possible. If you know that it has to happen.
Yeah. Anything to add?
I think my recent experience has actually been on the reverse side of them, and it's seeing opportunism. Opportunistic approaches are being criticised. If you don't need to oppose a relief application, don't make the stance clear and deal with the costs of that application separately at the hearing if you're dealing with multiple case management matters at once, so you can see, also a judge can clearly deal with those costs separately from the cost of anything else that's going on the day. So you can make your stance clear and you can protect your costs in relation to getting to the rest of the hearing from a broad brush assessment.
Yeah, I'd agree with that. My experience is that judges are increasingly unwilling to spend time that could be case management time on relief from sanction applications that should be by consent. Thank you all for listening, and we hope that it's been an informative series of talks.